Customary Use Ordinance Advisory Committee. And let the record reflect, according to the atomic clock up in Colorado, it is coming up on 1 minute after 5 o'clock Central Time here in Walton County, Florida, at the annex in South Walton County. At this time, I would ask that we stand and pledge allegiance to the flag. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The chair notes that apparently all 11 members of the committee are present at this time, and I will ask, the first thing that we need to do is to establish what will constitute a quorum. In the committee, I'm open for a motion on what would constitute a quorum for a meeting of this committee.
Mr. Chairman, I would move that a quorum is constituted by 6 members,
All right.
constituting a majority.
Okay. We're 11 members. Yeah, okay. There's a second to that. And is there any discussion? All in favor of the motion, please say aye.
Aye.
Any opposed? The motion carries. The quorum will be 6. I will also ask if you have had a chance to review the minutes of the last meeting that were sent to you. And if you have, do you have any additions or deletions or corrections that you wish to make? Is there a motion to accept these minutes?
So moved.
There's a motion to accept.
Yes.
And the second, is there any discussion on this? All in favor of approving the last minutes, please say aye.
Aye.
Any opposed? None. Okay. The other piece of housekeeping that we need to determine, if we're going to vote on motions, which we will eventually do, we need to know what constitutes a majority, what number of us constitute a majority. Is it a majority of those present, a majority of those voting, or a majority of all of the members? And I'm open to any discussion on this. Motion.
Do we have to do majority, or can we do unanimous? Just say that anything that we would move forward from this committee would only be done so if it was unanimous amongst us. We're all reasonable people. Surely because that would have us working towards agreement as opposed to lobbying and trying to, just work against each other. Is that possible?
Well, you can make a motion that the majority be unanimous, has to be unanimous.
I think that'll help us to work together so that we realize that our goal here is to come up with solutions that we're all good with, and then we can let go of the politicking and stuff and just talk to each other.
Is that a motion on your part?
That's a motion on my part. I'd like for us to work towards unanimous solutions.
Okay, does everybody understand Mike's motion? Mike's motion is that in order to pass anything, it has to be unanimous. That means all 11 of us have to agree to that. Is that my understanding of your motion?
Yeah. How about those that are present? That could be the exception if someone was absent.
All right. Correction. His motion is that it means that for anything to pass, all of us present have to unanimously agree. Is there a second to this motion?
I'll second it.
Okay. A discussion on it.
That seems a little extreme, to me, to get all 11 members at one time to agree on one topic. I would think that we could have, I hate to use the term supermajority or something like that. The 11 members maybe 8 or 10 have to agree, but there's always going to be some sort of dissenting vote.
Yeah, I think that, none of us had anything to say about what cross-section was used to choose these committees. I don't know, if we've got everyone but one person here on one side of the fence or the other about their views on it. I think we would do better if we just work toward the things that we agree on. The ordinance already exists, and we're helping the county to say, what can we do to make it better? So I really do think working towards unanimous decisions will help us so that we're not fighting with each other, and instead we're working together. We may not get, maybe we don't get as much done, but the things we do will be quality.
Mr. Chairman, my concern is not so much with the concept as the schedule that we're under and the starting point. We're not starting from a neutral place. We're starting from for some of us, a position that is quite distant from neutral, and we only have a handful of weeks to conduct our business. So the concept of trying to reach consensus, I think, is a great idea, but maybe we can set the bar just a little bit lower than unanimous.
Mm-hmm. Further discussion?
I agree, it's an admirable goal, but I would not want us to be held to that to make any recommendations at all.
Any further discussion?
Mike, what do you think about this?
It's a great idea. I'm kind of like some of the others. I think it's going to be very difficult. My wife and I can't even agree on where to go to dinner. The only concern I have is, and maybe it's a larger question that we should get into, since the ordinance has already been passed, I guess one of the questions I have is, what purpose do we have? What value are we going to be seen as having to the county? Because if the county commissioners have already voted, one of the questions I'd like to have defined is, what is our purpose, really? I mean, are we going to have several meetings and we're going to make recommendations? They're going to say, thanks, but we've already passed the ordinance. I don't want to waste any of our time. If this is cooked, served, on the table, then we need to know that in advance, and then our recommendations, we know, are just that, recommendations that are not going to have any weight. If there is gravitas in what we do, then I'd like to know what it is. So maybe that's a question that none of us can answer. Maybe Larry or Mark or someone else would have to answer. But
Well, I think our discussions will have weight and are available to the county, obviously. So it's not, if we didn't have a written recommendation at the end, it's not that this would be all for nothing. We're here with the public and we're sharing with them. They have an opportunity to ask us questions, I think, at every meeting at the end. And commissioners, they get to look at what we've discussed, so there'll be value. Having a proclamation at the end isn't necessarily the only value that could come out of our discussions. So I think it's okay that we might agree on things in a more unanimous manner. That leaves us free to have more open discussions. And I like to get into pro-con discussion, and will sometimes play the devil's advocate on the other side, but not if I'm constantly concerned about protecting the side that I might be on. We can be more open if we can just talk about things and try to agree.
Any other discussion?
Mr. Chairman, I had a thought too. I mean, I think the fact that the commissioners had us appointed and that we're here, they want legitimate discussion, and I think they'll want to come out with some recommendations. And just knowing individuals and groups and committees I've served on, I think it's going to be very difficult to get a unanimous vote on anything. And I would hate to see us spend the time and the effort of the county and not come up with something.
As the chairman, I can discuss this, and the only thing I would observe, it's entirely possible that this committee will come up with various recommendations to the county commissioners, some of which may be contradictory to one another. But in any event, also I would request, if we're kind of conducting this thing formally by the Roberts Rules of Order, but also in consultation with the county attorney, we're going to be having a mediator assist us in this whole thing. So we want to remain as informal as possible, but please address your comments to the chair, and rather than crosstalk in the meeting. Any other discussion on Mike's motion. And incidentally, I call people by their first name. If that's offensive to someone, just raise your hand or throw something at me, and then I'll stop doing it, okay? Is there any other discussion on Mike's motion? Does everybody understand Mike's motion? Mike's motion is that for anything to pass, any recommendation to pass to the county commissioners, that it must be unanimous by all of those present voting. Do you understand? All in favor of Mike's motion, please say aye.
Aye.
All opposed to Mike's motion, please say no.
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 The noes have it. Okay, the motion fails, Mike. Sorry. Okay.
Tom, can I make a suggestion maybe? Before we pick numbers.
If you can make a motion, yeah.
Okay, well.
Oh, go ahead. Go ahead.
Well, it's just a thought. Before we start like picking numbers for this, could we possibly go around the committee? And because this came up at the county commission meeting, and I don't think it was ever answered, who on this committee lives on the beach, who doesn't? So could we, I don't know if this is out of order or not, but could we go around and maybe state our names and whether we own property or live on the beach?
You want to make that in the form of a motion? See if we get a second to it.
Okay. I'm new to this, so you just help me through this. I'd like to make a motion that we go around the committee and, state our names and whether we own property on the beach or live on the beach.
I second that motion.
Is there a second to that?
I did.
There was a second. Okay, any discussion on that motion and second? Does everybody understand the motion? The motion is to introduce ourselves with the purpose of stating whether or not we live on the beach. Okay? Discussion on that motion.
Mr. Chairman, may I just ask what the purpose of that is? I mean, is that an automatic notice right here to say if you're on the beach, you're on one side, if you're not on the beach, you're on another? Is that asking the question?
Well, I mean, in reality, I think that the people who live on the beach may have a different viewpoint than the people that don't. And so I think if we can choose a number where that isn't exact, we all know where the positions that people are coming from. And I have to say, that was a question that someone in the audience asked of the county commissioners when this committee was formed.
All right, well, okay, the motion has been made. There's been a second. Any other discussion on the motion? All in favor of the motion, please say aye.
Aye.
All opposed? All right, the ayes have it. We shall go around the room. I guess,
I'll
from
start.
left to right, doesn't matter.
Okay, my name's David Bailey. I live about 2 blocks from the beach. I do not live on the Gulf. However, in my application, I did represent that I work for the town of Rosemary Beach, and Rosemary Beach is a Gulfront property owner.
I'm Brenda Reese. I live on Eastern Lake on the beach, but I was born in Defuniak. My mother was a teacher and lives up there. And my dad, when he died, was a high school football coach at Freeport, so I'm pretty much all over. Family's been here almost 200 years.
My name is Timmy Mills. My people are pioneers of Florida, the state of Florida. I live at the north end of the county, and that's about it.
And Lisa Bauschy, I live on the beach, but I also own inland property as well.
Lisa Evans, we're property owners in Rosemary Beach, and we're from Dallas, Texas.
I'm Tom McGee, and I live on Eastern Lake, across the street from Eastern Lake. I do not live on the beach.
I'm Chuck Schneider. I live 2 blocks from the beach. I'm new to the area, so this is interesting.
My name is Mike Sturdivant. I live a few blocks back from the beach in Blue Mountain Beach.
I'm Beth Clay, and we own property on the beach.
I'm Mike Huckabee, and we own property on the beach.
Celeste Cabina, I do not own property on the beach.
Okay. At this time, have we decided,
Can we have discussion? Is there room for that?
on what?
On what we
Do
just
we have a
discovered?
motion
Yeah. Do we need to make a motion to discuss
to discuss what?
just what we heard? Is it, I'm just, the order,
No,
what do we do?
No,
We can't discuss
if you
things?
Yeah, you can discuss things. Give me a motion, to what
All
you
right.
want to discuss, Mike.
Well, I would say that that's not an evenly divided panel as far as, beach to non-beach. So whatever numbers we decide, they should reflect that and make sure that there's a fair opportunity for things to pass or be declined.
Well,
Yeah.
yeah, this pertains, we're back to the motion of deciding how many votes it will take to carry a motion, okay? So at this time, I will entertain a motion, an alternative to the one that you made, an alternative to how many votes will it take to pass a motion?
Mr.
Will
Chairman?
it take, how many votes of those present, or those voting, or all members?
Mr. Chairman, I'd like to make a motion that we request that our mediator and/or the county attorney give us input as to any recommendations they may have
All right.
regarding how many folks would be appropriate.
All right? If there's is there a second to that motion?
I second that.
There's a second. Discussion on that motion. Does everyone understand the motion to ask the county attorney or the mediator to give us input? And I assume their recommendations on
Yes, sir.
how many that should be, but not be bound by those recommendations, I
That's correct.
assume. Okay? Everybody understand the motion? Okay. Any further discussion on that motion? All in favor of the motion, please say aye.
Aye.
Any opposed? None opposed. Motion, okay, well, that, we will lay this on the table then until we hear from the mediator, okay? The public in these meetings always has a right to speak. And in these cases, do you wish to hear the public before we commence our normal discussions as a committee, or after? And should there be limitations on the time limitations on individuals who speak from the public?
Mr. Chairman, I would move the adoption of a resolution that members speak after the business is conducted, and that members of the public be limited to, what is the current county, 3 minutes? That we adopt the same rule that the county does in a Board of Commissioners meeting in 3 minutes.
Is there a second to that motion? There's a second. Does everyone understand the motion on the floor?
Mike, when you said members of this committee or members of the public?
Public.
The public, and it has to do with the public. And the motion is that the public be allowed to speak after we conduct our meeting here, and that their individual speeches be limited to 3 minutes each. All in favor, or is there any further discussion? I'm going to ask. Any
Well-
further discussion on this motion?
Well, like to hear some of the public's thoughts, because they may have some thoughts or ideas or information that is pertinent to whatever discussion we're having. And, if we've closed business, well, what's the point of them even getting up and speaking? So I personally, I would prefer that at some point prior to a vote being taken, and, maybe at the end of the discussion of the committee, that we can hear input from the public, because I think that's very important.
Okay, that's not the motion on the floor, though, now.
Okay, but I just wanted to discuss.
Yeah. Is
Mr.
it-
Chairman, I have a question. Not that we're bound to follow the county's convention, but I believe that public comment on an action is allowed if it's relevant to that action or a motion, and that there is general public comment at the close of a meeting. I don't know if that was the intent of the maker of the motion or not, but
Any other discussion on Mike's
Mr.
motion.
Chairman, for clarification, that was the purpose. It's followed to the normal protocol of the county. But it's also in that if we have an unlimited amount of public discussion before we ever get to the agenda, then there may never be an opportunity to do that. We've been charged with that responsibility. I think it's very important that we have public comment, that's a part of what we have. But we also always have the right after public comment to rescind previous action if the public comment so directs us, or to postpone an action to the next meeting after the public comment. But I do fear that if we start with public comment and set the tone, the table, before we ever get to the agenda that we've been charged to follow, we may never get to that agenda.
Yes.
That's the rationale.
Yeah. Can I speak to that?
Further discussion on this motion.
Yeah, I'd like to say I pretty much agree with Mike with regard to that. But I do believe, we have members, many of the members of the public present with us who are probably most interested in this. Are we permitted to poll the room
Not
and
at
say,
this point.
ask them if any of them agree with 3 minutes, or if that's not?
This is not. We have a motion before us. We can
But
discuss
just
the
point of
motion.
order, I guess. Are we allowed to poll the room at any time?
No,
We're not allowed to poll the room?
not in this committee meeting right now.
Can I just make sure I've got this
Are we
clear?
sure about
So what the motion is that we have a discussion, we vote on something, and then a motion or whatever, and then after we're done, the public can get up and comment on the vote? I mean, they basically have no input?
That is the motion right now on the floor, and there's any further discussion on this motion.
Mr. Chairman, just to clarify the question I asked a moment ago and my understanding of Mr. Huckabee's clarification of the intent of his motion, and this is germane to your point, I believe the proceeding would be that we have a motion that's made and properly seconded, and the chairman would then invite commentary or discussion among the board, and then the county convention is that members of the public would then offer comment, and then we would be able to take action on that particular motion.
I have no problem with that, but what I was trying to understand is that the motion that was on the floor was that after our business was done and voted on, then the public would be able to speak. I want to make sure that's clear, and maybe it,
The public will be allowed to speak. There's no doubt about it. Any further discussion on?
Mr. Chairman, just so that everybody understands by Robert's Rules of Order, we can suspend the vote and hold the vote until after we do that on any time. But what we're basically saying, the motion is that we conduct our business. How we conduct our business is always at the discretion of this body.
Right.
And so that would be, if somebody moved that we hold off on the vote until we heard from the public, that motion would be in order. At that time, the board would determine whether we did. It just gives us flexibility. But as a general rule, it seems out of character for us to be charged with a responsibility and put the charged responsibility off until we've had an open forum.
Right. Any further discussion on this
Mr.
motion?
Chairman, I agree. I think if we do other than that, we'll never finish our business. The commission charged us with this committee,
All right.
not polling the public to see what the committee did.
All right. Any further discussion on this motion? I hear no further discussion on the motion. Let me reiterate the motion as best I can. The motion is that the public be allowed to speak after our meeting, that we will have public comment after that, but that the business of the committee shall take place prior to discussion by the public. Is that correct, Mike?
Correct.
Do I have it correct? All right, all in favor of said motion?
Aye.
Please say aye. All against it? All nay?
Aye.
No.
No, say no.
Nay.
Nay,
No.
okay, whatever, the motion carries, okay. Now, the next order would be, well, the motion included, let me correct myself, the motion included that the public's individual right to speak would be limited to 3 minutes
That was
on any issue. So that, to be clear on that motion, does everybody understand that again? All right, any questions on that? I think what we'll do is delay any further discussion of whether or not we should limit the time for which the public has to speak. Let's get to that later on. Okay, let's talk about, bring up the subject of limiting the members of this committee's time to speak on issues. Robert's Rules of Order says 10 minutes. You can choose whatever time we wish to choose. I'm open to a motion or no motion. Okay. There's no motion on the table. Then shall we? I'm sorry.
A motion 3 minutes. Just like the
Okay, there's a motion on the floor that the members of the committee's time to speak on an issue be limited to 3 minutes. Is there a second to that motion? There's no second. Oh, I'm sorry.
I second.
Okay, there's a second for that motion. Discussion, please.
May I ask a question, Mr. Chairman?
Yes, ma'am.
Does that mean that if somebody speaks for 3 minutes and then there's more discussion, can they have another 3 minutes potentially, or it's a single?
That would be my interpretation of it. It would be my interpretation, but I don't want to, is that a fair interpretation of the movement?
Yes.
Okay,
Yes, exactly.
all right. All right,
Discussion?
yeah.
So I guess we're just trying to prevent someone from taking up our time unnecessarily, it seems. So I don't know, I can't imagine what we would discuss that would take more than 10 minutes. 3 minutes, so we're really discussing how much is enough?
We're
2 minutes, 3
discussing
minutes?
one, whether or not we want any limitation, and if so, what?
Mr. Chairman, I would also note that the chair always has the discretion of allowing a member to speak longer if the
Yeah.
other members give consent. Without consent, they would be limited to 3 minutes.
Right.
If they requested more time, then it would be at the discretion of the body if the chair requested a vote. So
Sure.
Yep, that
while
sounds
we're limited, we're always able to do what we vote to do.
All right, there's a motion and second. Any further discussion on this motion? All in favor of the motion, please say aye.
Aye.
Any opposed?
No.
Nay.
The ayes have it, I think, okay? All righty, we've approved the minutes. We will have rest stops. Does this committee wish to curtail the length of time that it meets on any particular meeting? I will entertain a motion one way or another. Yea or nay, or there's no motion, there's no motion. That means that we're unapproved. All right, at this time, as I said, this, in consultation with the county attorney and Mr. Rob McNeely, who is here, who is a mediator and who has been asked to help us facilitate our business here. This is going to be kind of a hybrid committee between Robert's Rules of Order and mediation that Mr. McNeely is going to assist us with on our issues. So at this time, I'm going to turn the meeting over to Mr. McNeely so he can explain to us his function and see if he can help us along our task, okay? Thank you.
All right. Thank you, Judge. I appreciate it.
Whoops, just get
I
yourself
want to start off by
comfortable.
saying that was awesome.
Whatever, I know.
What y'all just went through, the process you just went through to figure out the ground rules of how you're going to go through dealing with the issues that brought you here. I want to talk about a few things about the process that we'll go through, about what my role is. I'll give you just a little bit of background about me, and then to start with, I want to, from the public notice meeting, oh, and I forgot, I'm sorry, I'm supposed to do this for the stream. Think you got me? Okay. From the public notice of the meeting is where I think we take our purpose, and that's what I was writing down while y'all were talking about it. That the purpose of the meeting is to review and discuss the customary use ordinance and report recommendations, ideas, alternatives, or amendments to the ordinance that would best serve the residents and visitors of Walton County. All right? So that's the charge from the Board of County Commissioners to the committee. And in looking at that, as the facilitator, and my role here is much more of a facilitator than a mediator, which means you all own the process. You all are the ones who live here. Closest beach from my house in Tallahassee is about an hour away, right? You all, this is your process. My job is to help the process move along, to help it move forward. And I would suggest in looking at this, that this language down here, best serve residents and visitors of Walton County, is your guide. And that everything else that comes from this might be guided by that, what best serves the residents and visitors of Walton County. All right. So that said, the passion, I think, that some of you, maybe all of you, bring to this issue is both notable and I think it's quite laudable. These are important issues. I have an understanding of the background. I have an understanding of where we are. Certainly what the Board of County Commissioners is looking for from you all. So if you arrive today and you're passionate about your position, I think that's great. I think that's good. I've never been involved in a facilitation or as an attorney when I'm involved on behalf of a party and I'm mediating cases where people don't have very passionate feelings about it when they arrive. And so, that's good. My passion is not about the subject matter. It's not about the content. It's not about the result. My passion is about the process, to facilitate it for you all so that at the end of the day, everybody feels they've had the opportunity to be heard. They feel that they may have come together. You may leave and you may not come together, but that the process has had an opportunity to work. Just by general introduction, and I won't spend a lot of time on this, I'm an attorney at a law firm in Tallahassee, one of Tallahassee's older firms called Messer Caparello. I have practiced law for about 2 decades. For a decade before that, I was a journalist, and then I changed careers and went to law school. My main practice areas have been in areas dealing with not real property, which is what you all are dealing with, but intellectual property, things like copyrights and trademarks. I don't do patent work, that's a whole different specialty. But I've also worked with families and family law cases. I teach as an adjunct professor at the Florida State University College of Law. I've done that for 12 years. I teach a course in entertainment law. I've been involved in commercial litigation, civil litigation, administrative litigation. I've worked on appeals, a number of things. And one of the themes that kind of run through those practice areas for me when you have a songwriter, for example, who has written a song, and there's a dispute perhaps, and I've been involved in some of these, between a songwriter and a record label about who owns the copyright to that song. I assure you that is no less important to those people than a mom and a dad arguing over custody of a child. It is that level of intensity, that level of passion, and if that's the way you all arrive here today, that's okay. I mean, that's good. That's good, and that's what we get to work with. I want to go through a couple process things. I want you to remember the sunshine laws. If two of you want to talk to me at the same time, that's a public meeting, and we can't do that. However, if you want to talk to me individually or email me individually, that's absolutely fine to do so. And I certainly can't be a conduit between two of you to circumvent. Nobody would do that, but sometimes we don't understand, and somebody asks, hey, would you tell the other committee member this? That's something I wouldn't be able to do. That would violate our very open Florida and the Sunshine laws. I am going to ask you in this process to dare to be different, to dare to maybe think a little differently than how you've arrived, to have ears wide open, and to be willing to explore alternatives, because that's one of the things that the County Commission has charged you with doing, is looking at alternatives. If mediations and facilitations that occur in the public have unique challenges with them. And some of you may have, and I don't know, but some of you may have very public positions on the issues that we're going to be discussing. If you do, and if in the process of working through this, you find yourself changing a public position and worried that somebody's asking you about that later, hey, are you backing off of what you said, or the article that you've written, or the op-ed piece, or the column, or something like that, to me, the simple response is, look, I promised that I would participate in this in good faith. The commission asked for alternatives and ideas. Right now, that's what we're doing. My position may not change, it may, but I'm participating in the process, and that's what you're charged to do. I did, with the county attorney, Mark Davis, he had initially said we'd be looking at 6 to 8 meetings, starting on tonight with the first regular meeting. I did ask him, and since this is your process, you all get to control it. I did ask him if the committee would be willing, if we thought it would be helpful, to have a longer Saturday session. 2 hours, especially leaving time for the public input, sometimes can be a pretty compressed time frame. We don't need to decide that right now, but I want to add that maybe a 10 to 4 on a Saturday if we think that would be beneficial. And again, you all drive the process, so you get to decide that. I just want to put it out as a possibility. During our discussions, and I talked about this with Judge McGee before we started, my recommendation to you and my invitation to you is that our discussions that we have are more by consensus rather than by Robert's Rules of Order. And what that means, eventually you will have votes to make, right? No question, you will have votes to make. And the judge is right. When you get there, you're going to be doing Robert's Rules of Order, you're going to be following, you're going to have your majorities, your quorums, and all those things that are required. Getting to that process, though, the idea of consensus is to get a sense of the group. And does the group agree, for example, if we're looking at one of the purposes of the customary use ordinance, and there's a sense that is an appropriate purpose for that customary use ordinance. We don't need to stop at that point and take a vote on it in a facilitating type of context. And the reason why is, as much as in our country we love the majority rule, and it's a fundamental part of who we are. One of the difficulties in this process with majority rule is majority necessarily creates minority. And if we can make an effort to be a little bit more inclusive than that in this process, that is often, it's often a good way to run the railroad, if you will. Now, consensus does bring with it some responsibilities, one of which is if we're asking for, do we have general consensus on this? And if somebody has an absolute hard and fast, no, I cannot go along with this, then you take the responsibility upon yourself or yourselves, if there's a group like that, to solve that problem, to come up with a solution to it. The idea is that we don't just have a veto that shuts us down, because we're all trying to work toward what is best for the residents and visitors of Walton County. I've been through this process many times. I've done strategic planning for corporations, for-profit and nonprofit. I've dealt with animal welfare groups, who are some of the most passionate people you would find, with very different viewpoints, and have worked with them to get a consensus on an idea. And so I'm excited to see what we can do here, and the way that we can go about it. So that's my invitation to the committee, that for our discussion, normally we start very broad and then we start narrowing it down as we go. We may very well end an entire meeting and not have a vote, and not need to have a vote. And so some of the concern about would we be closing business and only after that listening to the public, it may be that at the end of the meeting there is no vote to be had yet, and it'll be completely appropriate under the rules that you just adopted to hear from the public as well. So that's kind of the process that I see. Anybody have any comments or any questions about that, about me, about the role, about the purpose from the commission, anything like that? We good? All right. Then let's get into it. The first thing to look at, do you have copies of the customary use ordinance with you? Okay. And I understand that immediately after that one was passed, another one was passed, the beach activities ordinance that brought it in conformity. So here's what how I would like to start. And I apologize for those of you up here if I walk around behind you. I'd like to hear from the committee members. What are the issues with the ordinance? What's good about it? What's bad about it, in your opinion? Let's start framing those. Let's start framing the issues. Yeah, please. And would you do me the favor until I get to know everybody? And I'm sorry, I didn't get to meet you before we came in. What's your name?
Okay, David Bailey.
David? Okay.
Yes, sir.
Okay.
And Mr. Chairman, is it appropriate for me to address my comments to Mr. McNeely, or would you prefer me to continue to?
No,
okay.
like I said, this is a hybrid
Okay.
kind of a committee now, and the facilitator has asked you to discuss it, and we'll go this route.
Okay. If it's the will of the rest of the committee, I would love perhaps first, before we jump into the issues, maybe to hear an explanation of what the county believes this ordinance is going to do. I mean, that may sound pretty basic, but I'd like to hear someone's explanation of what this, what it is exactly where.
You mean what the county commission's intent was in passing the ordinance?
Yes.
Was that it? Okay. Sydney with the county attorney's office is here. Are you comfortable to talk to that?
I guess I could broadly speak to it. I mean, David, I guess to answer your question, the whereas clauses that you read in the ordinance state the purpose of the ordinance. So I guess generally the purpose of the ordinance was to establish the fact that the public has customarily used the beach since at least 1970, and to set some parameters on that use. So what would be allowed and what would not be allowed by members of the public. But I guess if you're looking for the purpose of the ordinance, the best place to look is in those whereas clauses.
Okay. Thank you.
All right, so as we look at issues, we could start, if you want, with the whereas clauses, or we could start with the substance of the ordinance itself. But you know, you all are here. You've given up your Monday evening. You volunteered to be on this committee. You know, talk to a stranger. What are the issues, David?
I don't mean to dominate the conversation. I'm just, as I alluded to, and when I introduced myself, I'm really sitting here in two. I don't see them as mutually exclusive, but I'm sitting here as a resident property owner. I go to the beach frequently. My young children, so I enjoy the beach down the street from my house. Happens to be one of the state parks. And then in my day job, I'm responsible for a portion of the beach in a different location, and a very different set of concerns in that capacity. I guess because I, as a resident, as a father and a beachgoer, there's so much what I perceive to be public access that's available to me and my family and friends, that I don't worry a lot from that perspective that I'm going to suddenly be looking at a different world come April 1st when this is adopted, when the regulations go into effect. However, it's a very different perspective as a manager of a section of the beach. The unknown of what it is that Rosemary Beach is facing in terms of challenges to its current operation. We have a large beach service. The unknown is a huge issue to that community. And that was the reason for my initial question. I'm really struggling to understand what the county's thinks is going to happen to communities like Rosemary Beach. If they think it's going to be business as usual, if something's going to change. That's so biggest issue I have is the unknown for communities that have previously been under the impression there's a private beach in front of their property.
Okay, all right.
Rob, I think,
please.
I'm Brenda.
Brenda,
Yes.
okay. It will take me, if we have 6 to 8 meetings, I promise by the 7th meeting I'll have everybody's names down. But yes, please, Brenda.
I see the main purpose here is that the Walton County Commissioners passed a customary use ordinance. And for that ordinance to go into effect, it will probably need to go to the Florida Supreme Court, if not the United States Supreme Court. And so one of our purposes would be to look at this ordinance, and if there are deviations perhaps in it that would impede it from going cleanly forward and passing at the Florida Supreme Court first and then the United States Supreme Court, those might be might need to be eliminated so that we help the Walton County Commissioners when they come April 1st to put this customary use ordinance in effect, that it is in its best legal form. I served on the redistricting committee for Alaska. Up there, the governor appoints 5 people, not the legislature determines it. And I worked on that 1990 redistricting and got it through the United States Justice Department. And I understand it's what we like and how we feel is one thing, but if we want the customary use ordinance to go forward and clear, which was the clear intent of all those public hearings that the public has already had on customary use, and the commissioners voted for that, that we see, that we help that be as legally sound as possible.
Okay. So do I, and David, did I capture yours here by saying the unknown, one of the issues is the unknown effect of the ordinance?
Absolutely.
Okay. And is that countywide, or at least beachfront wide, or is that just peculiar to Rosemary Beach?
In my conversations with other communities, Seaside and Paradise by the Sea, others, those are just a couple specific,
Right.
that's, I believe, a very common concern.
All right, and then, and Brenda, you want to make sure that the county has, implements a constitutional ordinance?
Right,
Is-
yes.
Okay.
That it clearly, like say, for instance, the Tony Rama case that has been cleared through the Florida state, that it's maybe as clean as that is, that gets through.
Okay. Okay. Other issues, Governor?
Ronnie, it would appear that we may be getting ahead of ourselves, because if we're talking about the legality of this ordinance, and I understand there are, how many? 2, 3 lawsuits?
Yes, 3.
3
Right.
lawsuits.
3 pending, sure.
We can't litigate that. We have no authority.
That's right.
And the county right now, which means all of us, are paying lawyers several $100s an hour to litigate this. So my question is, to what purpose are we going to be acting toward a customary use that the county has already passed and that is currently in litigation? It would appear that it's almost as if we need to recognize that we have a very limited role, which is simply to state a group of opinions of the people who live here, varied as they may be. But I'm not sure what problem is that we are trying to solve.
Okay.
And I would raise also,
Sure.
what problem are we solving with customary use? I mean, is there a vast problem of people who want to access the beach and cannot get to any part of the beach, or is it that they just cannot get to every bit of the beach they want to get to?
So is
That's
it,
a different question.
is it a problem in search of a solution or a solution in search of a problem?
Right, and the second part of
All
that
right.
question is, and again, this may be one for the county attorney, what is the budget that the county has established to litigate this? How much money is the county willing and set aside to spend to take this to the Supreme Court? Because we're talking about an extraordinarily expensive process, and if we're all paying for it, I think we'd kind of like to know if there's a budget here, and what is it? Because the sky being the limit would probably not be a good answer for most taxpayers.
Well, Governor, if I can address I think the first part of your comment about, getting ahead of ourselves. From my conversations with the county attorney, clearly the lawsuits have been filed, right? And I think the first one raises free speech issues. It raises takings issues, both constitutional level questions. You all are not a constitutional body, so you don't get to make that determination. What I understood Brenda saying was that she wanted that to the extent that you all make any recommendations, ideas, alternatives, or amendments, or say that we think that it's okay as it is, you just want to make sure that, based on the best advice that it's constitutional, that the ordinance itself is constitutional, even though the Florida Supreme Court may disagree, the U.S. Supreme Court may disagree. Did I capture that part right?
May come in later.
The what may come in
And
later?
judges can always come in later and fix it
Right.
themselves anyway.
Right. Right. And
It's
so,
diligence to.
so it may be, so I think it's just like, when the Arkansas legislature passes a bill and they, back in the day, would send it to you, they presumably wanted it to be the most constitutional bill possible. And so
They really didn't.
there is that. There is that. Sydney on budget and litigation.
I guess I can't really speak to a budget per se, but I can tell you for the 3 lawsuits that we have filed right now. For one of them, Mr. Davis is the attorney of record, so any work on that's covered by his salary. And then for the other 2 lawsuits we have insurance coverage. So our insurer, Florida Florida, it's FACT, I don't know the acronym, but they cover a large portion of those attorney's fees. The only portion that's not covered is Mr. Theriak's.
And what is that budget?
I can't speak to that.
And if the county loses and is required to pay attorney fees for the plaintiffs, is there a budget for that?
Those attorney's fees would be covered by our insurance
Would that-
carrier.
okay.
Yes, sir.
Good news.
Okay. But Governor, did I paraphrase that okay? What problem is being solved by the ordinance?
And whether or not that this committee is ripe,
Okay.
given the fact that there is not only an ordinance passed, but there's litigation against it. That's the concern. So what is the scope of our purpose given that we really can't make a recommendation that the county can act upon, given that it's being litigated currently.
Well, and that's an interesting point, and Sydney, maybe you can help with that. My understanding is that the ordinance itself, the 21623, doesn't become effective until April 1 of 2017. Is it, could it be amended prior to that effective date?
Absolutely, and that's the goal of the committee, is to come up with
Okay, so that may address the rightness issue, maybe. I mean, the litigation is still there, and the litigation on the constitutional questions probably isn't likely to change, I would guess. Okay? All right, so did I capture that okay? What problem is being solved and rightness scope given the litigation, just as we go through issues? Yes, please.
Well,
What was your name again?
Celeste.
Celeste, thank you.
I'm just thinking back to, you know, what you stated. How can this ordinance and this committee best serve the citizens and residents and tourists of Walton County? And so that's where, you know, I don't think we need to worry about the money and that sort of thing. That's someone else's problem, you know. But my understanding of this committee was that we were to look at this ordinance, and we may, like someone said, say, this is great, we think it's perfect, move forward. Or we may say, what if we changed this? What if we tweaked it in this way or that way? And I've already got some thoughts and ideas on that I hope we can discuss at some point. And so I don't think we're looking to reinvent a wheel here, because I think there's been discussion since last probably February on this issue, and a lot of study done on it. And I just think this is something that the county says, you know what, let's just do, let's do a check on this and just make sure that it's something that both, as we have here, people that live here, live on the beach, recreate here, whether you're from the north end or the south end, it's good for all of everybody, and it'll work for everybody. And that's where I think the objective of this is. And I want to say, I'm sorry to keep going, you can time me if you want, but you know, we all got here, and the reason we're here is because of, if you want to talk about issues, is I've been here a long time, and a lot of other people have been here a long time, and the more people that move here, the more development, things just don't work the way they used to, you know. And we need to make sure that things that we maybe took for granted as residents here or visitors here, we took for granted that we could go down to the beach and enjoy ourselves on a whole variety of beaches. We didn't have to limit ourselves to the parks or anything like that. And I think that's changing as more people move here. So I think we need the protection of our government so that we don't lose that right. All
right. So would it be accurate to paraphrase at least some of that an issue that you think needs to be addressed is whether the ordinance actually accomplishes this mission down here? Does the ordinance best serve the residents and visitors of Walton County? And keep in mind, think of this process as a funnel or an upside-down pyramid. We are starting very broadly, and that's intentional, because at the end of, I'll say end of the day, but take that metaphorically, at the end of the day, we'll get down, to these ones, recommendations, ideas, alternatives, or amendments. But to get there, we're going to start very broad. So if you think we're being a little too touchy-feely, if you'll give me the leeway for that while we start, that is intentional, and that's part of the process. So I'm not asking you to solve whether the ordinance does this just yet. But is that what you're saying, Celeste, that does the ordinance best serve the residents and visitors of Walton County?
Well, to me, that's, like sort of our mission statement, so to speak, and I'd like to see that written and stuck on the wall so we can see it at all times. And if we feel like we're getting somewhere on a tangent or off track, you go, well, let's go back to the mission, because if not, like you say, we'll go 6 to 8 weeks and have nothing because we're off on tangents. And I think that'll keep this committee on focus.
In the trunk of my car, I have Post-it notes of this size that our next meeting I will bring in, and I will literally rewrite that and stick it on the wall so we can look at that the whole time, okay? So do you want to put that in, or do you think that's just kind of the overriding reason that we're here?
Well, if you want to add an issue, I would say the issue is that we need to ensure that the residents and visitors of Walton County can continue to enjoy the beach as they have since time immemorial.
Now, is that a goal that you'd like to achieve out of this
That's a
committee,
goal
or is
I'd
that
like
an, okay, or is that an issue with the existing ordinance?
I think it's an issue because the issue that started this whole thing was that people got kicked off of beaches that they'd been using for years.
Okay, so help me frame that in the way that we've done up here with a handful of words. How would you frame what you're saying? And I'll try to pull it out with based on what I heard.
I'm sorry, I can't give it in 3 words or less, but I'd say...
He just did.
Yeah.
That was pretty good. What she said.
What did I say? Yeah.
Try it again.
You know, people can continue using the beach as they have customarily, you know.
Okay, and so since we're looking at the ordinance, right, and the issues with the ordinance, would it be, does the ordinance...
does it allow people to continue using the beach as they have?
Okay. Let me put that down.
I don't want to say it's stated that way. I think that could work for both sides. I can imagine if you're a beachfront property owner, you're thinking, does it allow me to use the beach the way I customarily have? Is that not a concern that beachfront owners have? Is it? Maybe it's not. I just thought maybe it would be.
Yes. No, it would be.
Okay. So that's a pretty fair statement, I would think.
Rod, can I make a statement here?
Please.
All right. It appears to me that the county commissioners adopted this ordinance to recognize what they perceive to be the ordinary customary use of the citizens. This has offended people who think that they own down to the waterfront and may have property rights. And they have brought lawsuits alleging violation of constitutional rights. The lawsuits are not going to go away. If this committee can come up with any sort of reasonable, solid recommendations that would cause these lawsuits to go away, then it would appear to me that the committee would be doing worthwhile business. Now, the only way that that's going to happen, it seems to me, is that if we sit down as a committee and reflect on what do we propose that will amend this thing or this ordinance or modified in some way to get to that results. Come back, let's discuss it, and either pass it or not pass it and go on. But we're not going to sit here for another 6 or 8 meetings flopping our gums here. I'm not going to sit here for 6, 8 meetings doing this. You know, either this committee comes up with something tangible and passes on to the county commissioners something that they can do to amend this ordinance to avoid these lawsuits, then we're doing no good, you know, for anybody.
You know, I agree with that, but it seems like we're trying to start grandiose. I mean, what you just said is really in the first whereas. I mean, basically, shouldn't we look at this, understand what this says,
Yes.
and go through this step by step and see where the problems exist instead of trying to create this grandiose shell on top of it?
Well, I mean, let me ask you, and like I said, this is your committee, this is your process, all right? So you get to decide, and if that's the consensus of the committee that you'd like to go that way, we can. The reason that we started here, all right, was because of the charge from the county commission, which was pretty much to take a comprehensive look at the customary use ordinance. And in my experience, it's often helpful before we start trying to come up with solutions to see if we can agree on what the issues are. I mean, the judge will, tell you that people who appear in front of his court, if they can agree on the issue, then you're arguing about the same thing. But if they can't even agree on what the issue is, then it goes all over the place.
But the issues are here. I mean, do you have an issue with the 15-foot buffer? Do you have an issue of what dry sand is? Do you have an issue of the owners of the properties that contain a portion of dry sand areas, beach may make use of their property,
All right.
which is...
Let's
what
flip
are
it then.
I think we have to define what the issues are before we can actually start to, try and come up with a solution.
Ron,
And
let's
what's
just
best.
go back to the question, though. How big a problem is it? What is the scope? I mean, there are 800 beachfront owners approximately, is that correct? In Walton County?
There's
1,100.
900 parcels.
900 parcels of property. So how many parcels present a problem? How many times have people gone to a part of the beach and were thrown off? Has that happened once? Has it happened 100 times? And did it happen because the people who were accessing that beach, did they litter? Did they make a lot of noise? We're trying to solve a problem no one's defined. I'm not sure how we do that. I mean, I see the whereas, and I get that part, but there's also the balance of the constitutionality of people's property rights. And if people are paying the taxes on a piece of land, but they don't get to restrict how it's used, they don't own it anymore. So I think that's really one of the questions that our committee needs to look at. What are we solving? Are we solving a problem where in 900 parcels of property, only 200 are accessible and 700 aren't? Is it that people can't get to the beach? Or they can't get to just every part of the beach they want to get to because when there was no development on the beach, it wasn't an issue. And if it isn't, then, I mean, that's one of the issues of any development.
Right.
So I'm asking that if you could help us work through that question, because I don't think we go anywhere until we define what problem are we attempting to solve.
Yeah, I think we have
Okay.
several problems.
All right.
Right.
Okay. Let me go Brenda and then Mike, I
I-
believe.
Again, going just back to, we're here to give advice on customary use, which is a separate issue that the county commission passed, and that we need to reflect, like Tom said, on what we proposed to, this is great, or any amendments. A lot of the other issues are beach activities issues that are separate from this customary use. Customary use is a very particular legal status that the citizens have a right to. And so that is separate than, no, you can't have glass, you should take your stuff off the beach at night. That's a completely separate issue, beach activities and how that is managed and by the county. So I don't want to get into, again, we could talk about that for 8 weeks, no tents, no umbrellas, but that's not the issue before us. Customary use is the issue before us,
All right.
not beach activities.
But they are related, right?
That's not the issue before.
Right, no, I understand that, and that's what I'm wondering, is the relationship between the beach activities, which is the next ordinance that was passed right after the customary use ordinance, is it so intertwined, and this is really a question, all right, is it so intertwined with the customary use issue that they can't be divorced for discussion? And I don't know, I'm just asking the question.
I think you can.
I think they can.
You think they can?
I would
Okay,
think-
okay.
I would think they
So-
have to be.
Okay.
Because we're not charged with that.
Okay, so here's a suggestion. Let me hear from Mike, and then what we'll do is, if there's, unless anybody has anything else to put up here, let's start picking out which ones you want to talk about first. And if the one that Governor Huckabee mentions is where we start, we can start on that. Does the ordinance use a sledgehammer to kill a fly? Or is it an appropriate exercise of government authority to prevent a small problem now or a bigger problem later? Let's see, Mike.
This may be stepping back now, but I was responding to Mike, whether it seemed like you didn't have a full grasp of what the problem might be, or what, if there was a problem, why we're doing all, but maybe this isn't what you were saying. But personally, I've had problems with regard to beach and beach access and use, and over the years, our ability to use the beach has been diminished from what it was back when you could, like you said, walk all the way down the beach, and usually there's nobody there, honestly, just 10 years ago, much less 15 or 30 years ago. And there's places, maybe it's where the county has made mistakes, where, like in our neighborhood, Blue Mountain, where there's a platted beach access, but there's a wall on the property, and you can't, there's no path, no place to walk and get down. But the county's given that up. The developer built a wall, and they left it there, and now there probably won't ever be a beach access at that spot. At the end of your street, like just a few doors down, it used to be we walked down that street and we would walk down a path to the beach and go surfing right there, probably a few hundred yards from your house. I used to surf there all the time. 2 days ago when I went surfing to get to that spot, I walked out a public access and carried my board down the beach to drift back down current. And I would just say that there are real reasons why where you can get to the beach matters, and there is a real problem with the amount of those accesses has diminished over time. And as our population increases, the population of folks that we invite in and the people that live here, if the accesses diminish and if that size gets made more and more small, we're going to have more problems than we have right now. And even if we have ordinances that if this were to just pass right through and we all came to agreement, I don't think we'll probably make some modifications. But if it did, there'll still be people there'll be have to be some sort of intermediary. When that guy at the beach in Santa Rosa Beach comes down and threatens people and yells at them, I don't think that kind of behavior is probably going to change because we pass an ordinance. That's just somebody being mean. The ordinance isn't going to stop people from acting like that. But there are real problems, and people that I know, maybe it's just because they come to me, and when they're upset and they've been threatened or they felt frightened from people treating them poorly. I know there's real issues, and that may not be something that you come across. They may not call you when those things happen, but they certainly call me when those things happen. So.
Right, that works both ways.
Mm-hmm.
I mean, when a visitor from out of state comes to your own property
Mm-hmm.
and threatens you.
Sure, right. That's
I mean,
not acceptable.
I think that works both ways. So
I
I don't
agree
think
with
it's
you.
property owners only that are, quote, being mean, if that's what's being said.
Yeah, no, I would absolutely agree that there's probably problems on both sides of that. But I was just speaking to the idea that, there is a problem, and it has changed. It's not the same as it was. It used to be, it was very rare that we would run into someone who was having any kind of difficulty as far as access on the beach. But recently, it's become a real problem where we see
Mike,
it.
is the question a matter of access or behavior?
I think mostly it's probably behavior. Though access is affecting that because as people are having less and less area to enjoy the beach, then I think there's more misbehavior on both sides. If we were able to go ahead and use the entirety of the beach, I think there would be less behavior problems.
The question then comes, if you talk about the entirety of the beach, if a person has a deed that says that they own to the high mean water line, and someone comes all the way up to the or comes up their walkway, gets into their property. I mean, I guess the question is, where does
and that's an important issue.
You bet it is.
Because but this is a hot button issue for folks on the other side, because we know if we've been here for more than 10 years, I think, that a lot of people had their deeds changed, and it felt underhanded to the public. It may have been, maybe it was legal, maybe it wasn't, I don't know. But to the public, it felt like those things happened behind closed doors, and it didn't seem appropriate. Let me just say that. And so even those things are really in question to the public. That's a big issue.
Let me make a suggestion I can. Based on that discussion and everything else, by my count, you all identified 7 issues.
Okay,
all
just
right?
7?
And the last 2 that I added during that discussion were the whereas clauses, that maybe that's the appropriate place to start and just dig into the whereas clauses and start working right on it. Is the ordinance addressing access, or is it addressing behavior? And if you can't see, so what they are, and I just numbered them for ease of reference. Unknown effect. Number 2, constitutional ordinance, is it? Number 3, what problem is being solved? Number 4, the rightness and scope of y'all's work given the existing litigation. Number 5, does it allow use of the beach the way it has in the past, the way the beach has been used in the past was the way that was phrased. Number 6, the whereas clauses in the actual ordinance, do they accurately reflect what the ordinance, the basis for the ordinance? And are those, not only do they accurately reflect the basis for the ordinance, but are they factually accurate in and of themselves? Because if the whereas clauses unintentionally make a misrepresentation, almost by definition, the resulting ordinance is going to run askew, all right? And then 7, is it addressing access or behavior? So what I'd like to do now is have you all, and not necessarily by any formal vote, decide which one of these we dive into first. And I'll just go down by consensus. You can just kind of indicate, let's do that one, and we'll just listen and see if we get a sense of which one the committee thinks we start on first. So, and by the way, there's no pride of authorship in this, all right? So it doesn't matter who it came from as to, it's the topic, not the source, all right? And by the way, my intention at 6:15 right now, I was told we were scheduled from 5 to 7 for these meetings, so my intention would be to have this discussion for about another 25 minutes so that we wrap up our discussion by about 6:40 to allow time for public discussion, but the judge is the chair, so I'll defer to you on the meeting order, okay? All right. All right, so, by consensus, start with unknown effect.
I think that ought to go last, personally, because I think maybe in discussing all these things, the unknown may become somewhat of an idea of what may happen,
All right.
And I wanted to make a comment earlier that, the county here is not, and it's kind of very refreshing to have seen the county look at an issue that really has been an issue for a number of years, and they kind of ignored it, to be proactive and say, you know what, this is only going to get worse. The having people not be able to use beaches that they've been able to use for years and years, and they got proactive with it. I mean, that's, they deserve a gold star for that, because we don't see that all the time.
All right. So how about, is the ordinance constitutional? Want to start there?
I think that almost waits after the whereases too, in a way, because the whereases maybe have issues that are maybe not the strong constitutional
All right.
issues.
All right. And when I'm saying all right, I'm really just acknowledging what she said. I'm not saying I agree, so you jump in if there's other input, all right? We want to start with asking what problem is being solved. Is there a sense of that? Or
What if we start with the whereas clauses and just go
Yeah.
item by item? Just line item by
we'll
line
skip
item.
down to number, well, rightness, does it allow the way it's been used in the past?
I think that's one of the primary issues here. Yeah. I mean, if it's not helping with that, then why are we going to all the trouble?
And I just asked, that's what I was asking, is number 5 contained in number
Right at
6?
the top.
So where number 5 might be contained in number 6?
It is, appears to be the first one.
Yeah? And then also addressing access or behavior. See, when we're talking about consensus, I need to hear some volume from y'all in some capacity. I hear some agreement that we should start with 6. Is that the sense of the group, or at least
I
this?
think if we do the whereas clauses, we're going to answer number 5.
Yeah.
All right.
Like it does
I agree.
allow use, is
So-
under the
so may-
whereas,
so maybe-
it's longstanding, is it longstanding use? So that's in there.
Okay, so maybe number 6 is going to shed light on number 5, and also maybe on number 2 as well. I think I heard somebody mention that constitutional aspect, it may dissolve once we get there, and maybe once we get through all the discussion, the unknown effect will become more known, possibly. So you want to start with the time we have remaining tonight? You want to start with the whereas clauses?
Yes. Yes.
Good? Okay.
If I might,
Please.
on the whereas clauses, the first two, I doubt there's any disagreement, but certainly if there is, somebody speak up. I think we all realize that everybody recognizes the beaches as a treasured asset. I think we also all recognize that it's a vital economic asset. So if anybody disagrees, please speak up. But when it gets down to number 3, we're into time immemorial, and that's really not a clearly defined concept, for one thing. And for another, I genuinely believe that if customary use were so clear-cut and obvious, that Walton County would not be the first county to be trying to apply it to the entire beach.
I can speak to that.
We have a wide variety of constituents that are beachfront owners. They range from individual property owners that own, 50, 60, 70 feet or whatever, to Rosemary Beaches, sorry about that, to Rosemary Beaches, or to condominium complexes that were sold parcels deeded down to the mean high water line. Even among the beachfront owner contingents, if you will, there's a variety. So this one size fits all doesn't fit all. And what concerns me the most is that while customary use is certainly recognized in the state of Florida and other states, there's some pretty precise standards that have to be met, and they're determined by judicial branch of the government, not by the legislative branch typically. Now, there are exceptions to that, and there are other states, but I just think it's real important that we recognize that whatever we do here is probably not going to really change. We can try to make it where people get along on the beach better, which I think is an admirable thing to do. I think doing it by a customary use ordinance that applies to 26 miles, and I've heard 29 and different numbers, but the number I heard most was 26 miles. And of those 26, I believe there's roughly maybe 6 miles or 8 miles or something of state parks, and all of this doesn't apply to them really anyway. So I'd like to see us just focus on, is there a way that we can go back to people getting along on the beach without having to have lawsuit after lawsuit to determine it? We have people like, and I don't live in Rosemary Beach or any other condominium complex, let me say that up front, but, they have certain things that were promised their buyers when they bought in those areas. And we're now basically changing not only an ordinance that may or may not be judicially acknowledged when it comes right down to it or not, but we're changing HOA rules and all kinds of other things too. So I'd like to see us focus, instead of trying to make an ordinance work, make a set of let's get along on the beach etiquette that we can all get along together like we did before. And part of that does boil down to beach activities, because once upon a time there were not 2 million people on the beach. I've been coming to these beaches since I was a little girl. I didn't live in Walton County all the time. I lived in Okaloosa part of it. But my parents bought a lot many, many years ago, back in the early 70s. So I can tell you that there were times you'd see nobody on the beach. Those days are gone, and we all get that. But walking on the beach, yes, people did that. Throwing a towel down, or maybe having a little lightweight chair. But when you start looking at things like vendors all over the beach, and I'm not trying to pick on the vendors, they serve a very useful purpose too, in the right places, in the right circumstances. But, umbrellas and chairs all over the beach, stuff being stacked all over the toe of the dune every night. Oh, those are differences. Those are not customary use. Those are changes that have taken place.
All right, so would you be comfortable then if as we work through these whereas clauses, we keep that in mind, that
Sure.
whether it's the etiquette or can we get along and see you know, if this ordinance sheds light on that goal.
It just
we kind
sort
of keep that in there?
took 3 out.
Okay. Okay. Let me, if I can, okay, all right, discussion, let's see. Here, Mike, Brenda, okay?
I'd like
And
to
I'm sorry.
follow up.
I know
That
your
was-
name's not here, please help me.
Lisa.
Lisa?
Lisa.
Lisa, oh, okay.
Right. We sit next to each
All
other,
right,
yes.
okay, thank you.
As a homeowner in Rosemary, I would like to address that when we did purchase, we've owned in Watercolor and we've sold, we've owned in Seacrest and we've sold. When we purchased in Rosemary, that's what we loved about Rosemary, was the private, and I'm going to use that as a, for lack of a better word, beach. That's what we bought into. We bought that. If this goes away, and yes, Rosemary Beach is so crowded, we do rent our house out. It's packed. All spring, summer, we can never use it because it's always rented. There's so many people there. But I do understand the stacked chairs, the umbrellas, it's a mess in the summer. But as a homeowner, when we purchased in Rosemary Beach, we were promised this would be a private beach for us. If that goes away, our property values go down. And there goes tax value for the county. That's just it's going to happen. And development is not ever going to stop, unfortunately.
All right, Mike and Brenda, and then let's dig into the whereas clauses, okay?
Yeah. So, and this just opinion, but when you were saying, well, why is it happening? I think, interestingly, it's happening in Walton County really because we have the luxury of developing later than other counties, and other counties have, became so entrenched in this is my part, this is their part, you can't come here. That happened in other places in Florida, and our commissioners have that the wisdom from the problems that happened in other places where they didn't state clearly on the record that customary use is an important part of our community. And so our commissioners, because I know that there's a lot of development has happened now, but we're developing late comparatively to Florida. So I think some of what you're seeing is why is it happening in Walton County? Because we can still do it. Because in Walton County, we can still make sure that the public has that access. And with regard to time immemorial, it was clear in the presentation, and I think common knowledge around here that people have been using the beach since before there was recorded history. That I think my community, Blue Mountain, reportedly got its name, from the ship captains that saw the blue lupine on the beach there. I guess it might be the first record of Blue Mountains, specifically, but there have been people using the beach for every purpose since then. But
Okay.
on the other, the promises to the buyers, I haven't heard this mentioned yet, but I purchased with the knowledge that I would be able to, and my children would be able to use the beach as we customarily had, and every buyer in Walton County has, our friends in Freeport and Defuniak, many of them are living where they are because they know they're close to the beach, and so they that's part of their payment idea when they buy a property. They're like, yeah, I'm only 10 minutes from the beach. I'm only 20 minutes from the beach. I'm only 45 minutes from the beach. So to think that only the beachfront owners are affected by that thinking in their purchasing, just make sure that you're considering that everybody, and I can at least speak for myself, absolutely, that the proximity to the beach for me, I want to be able to hear the surf. If it's big enough to hear it, then I know to grab a board and go surfing. That's how I chose where to put my house, right? That's how I chose where to live.
Okay,
So,
let me go.
that
Brenda?
affects everybody.
First off, actually, Blue Mountain Beach was actually known as Double Yellow Bluff
Okay.
before that Gene Wesley 2006 letter to the editor, I believe, in the
Thank you.
Northwest Florida Daily News. But,
That's why I said it. Maybe
customary
you
use, again,
yeah.
is separate than the beach activities, but I think the owners need to be protected. And customary use, I was the legislative aide for Representative Beth Kilmer in 2000 when she was the representative for all of South Walton. And I remember going to a hearing for her where customary use was discussed, as well as the term, once public lands, it's public lands in perpetuity. So I would just add that this is not a new issue of discussion for this area. Maybe we could go back. So even as around 2000, the idea of customary use was being discussed at the government level.
Okay. And Celeste, let me ask you just to be brief, because I want to get into whereas clauses before we hear from the public.
Okay, I wanted to make a comment about the fear or the unknown of some of the communities like Rosemary Beach or Seaside or Watercolor. Well, one, I don't think the crowds are going to go there and trying to get on the beach, because my understanding is that the accesses, you have to have a code to get in. You just can't walk on their walkovers. And I don't know why anyone would want to go to the beach there, because you can't get a parking space. So to me, that doesn't, because there's a customary use ordinance, I don't think all of a sudden hordes of people are going to go and use those beaches. There's a whole lot of people on those beaches because they're dense developments, and I think the people that are on the beaches there are the folks that are staying there, you know, people that are coming in and they may go there to shop, but I don't think they're gonna, there's a whole lot better places to park and get to the beach with an access that you don't need a code that people are going to go to, you know? And if they walk in a little bit from the side, I mean, I can't imagine that's, people want to do that and haul all their stuff that they feel they need for the beach, you know?
Okay. And I appreciate the comments. If it seems like we get off track, sometimes, in my experience, this is important that y'all get this out. Y'all hear what each other's saying. You may have heard it for a year now in, articles or other public hearings and stuff, but this is U11, and this is something U11 have been tasked with trying to figure out. So I appreciate your patience in doing that. Yeah, David? And then we're going to get to the whereas clauses.
Well, I'm jumping into the whereas clauses.
Okay. Then as you do that, can I ask any objections to numbers 1 and 2? I numbered them. They're not numbered in the ordinance, but there are 12. The first 2, everybody agree with?
No. Like my first comment has to do with number 2.
Okay.
And this goes to a certain extent back to my comment about the unknown. Of the 12 whereas clauses, only one truly makes a statement about private property rights, and it's a pretty fluffy statement. Whereas the county recognizes and acknowledges the rights of private property owners to enjoy and utilize their property. And that's about all that private property owners know, is that the county's just acknowledging that. There's some description about, a couple of them have to do with the 15 feet, the buffer zone. But the others are all really, the other whereas clauses really describe what the public generally will be able to do. And so, and just in case anybody on the committee or audience isn't aware of it, my employer is one of the filed a complaint against Walton County. We were one of the folks who levied a lawsuit, and we did so because we believe that the procedure that this was adopted was improper, and that the courts will sort that out. I'm not here to comment on it, and that's just that. So I do think, as I stated earlier, it's a very, very serious issue for this community to sort out, is how do we provide everybody that has a right or a reason to want to enjoy the beach. It's something that it literally has no quantifiable, the beach itself has no quantifiable value. It's you can't put a price on it. But you can certainly put a price on the investments that various folks have made, whether it's Mr. Sturdivant, who, like me, personally invested so I can be a walk from the beach. But I also recognize that the local economy is built on the massive investment that folks have made. A lot of the property value in this area is driven by the Gulf Front owners. And so for there to be an ordinance that has these 12 whereases and only one of them make a very flimsy reference to private property rights, to me, is unacceptable. There has to be some definition. Assuming that the procedural issues are sorted out and the county and the community commits to say, we're going to work this out, we're going to do all the things we got to do, we've got to have an ordinance or whatever mechanism that is more descriptive of what's going to happen for the private property owners who have made these massive investments that our local economy is in fact built upon.
Do you already have some idea of what you'd want added to what you're talking about, number 7?
Can I make just a process suggestion? And that is that we go a little bit more in order, or else before long we're going to be all over the room, okay? And so what I'm trying to get from you, David, is that you would like to see whereas clauses that have a better balance between public and private?
Absolutely.
Okay.
And specifically, just to use the second whereas the dry sand areas of all the beaches in Walton are in the county are a vital economic asset to the county and the state of Florida. You know, I could read county in two ways. Is it a body politic, or is it the community of individuals, including the private property owners?
I have a question for all 11 of you, and that is in the very first whereas clause, whereas the recreational use of dry sand areas of all the beaches. Do you all have a consensus of what a dry sand area is?
Well, that was explained in the presentation on the customary use. And
Okay.
it's in a lot of the various documents.
Right, no, I understand, and that's what I'm saying, is that are you all operating on the same understanding of the use of the term? Because if you're not operating on the same understanding, then, you know, by the time we get to the bottom, we're going to be wide apart. So you all have a consensus of what dry sand areas are. All right. This may seem very basic. Do you have an understanding of what the beach is? A common understanding of what the beach is? In the ordinance that was passed after this one, it defines beaches. If you look at it, it defines beaches. The beach means the soft, sandy portion of land lying seaward of the seawall or the line of permanent dune vegetation. I can read that again if we need to, but do you all agree that that is the definition that we're working with of what the beach is? I don't hear anybody saying no, so I'll take that as an agreement. Okay, I just wanted to make sure that, because those are two real fundamental issues. All right, so we've got about 5 minutes left. Anybody have any other thoughts on the whereas clause number 3? And just for those who don't have a copy of the ordinance, it says, whereas the public at large, including residents and visitors to the county, have utilized the dry sand areas of all the beaches in the county for recreational purposes since time immemorial. Sydney, is time immemorial, is that a term of art that derives from that Florida Supreme Court case, do you know?
Yes, sir.
Okay, and it just means exactly what it says, time immemorial?
Yes.
All right. And does that phrase have a legal impact? In other words, if you declare that the beach has been used this way since time immemorial, is there a legal result of it having that declaration?
Right. Well, there's certain factors to establish customary use, and the first factor is that it has been used since time immemorial.
Okay.
So the idea is that you want to meet one of those factors before customary use can be established on any beach.
Okay. So are we asking right now, is that a factually accurate whereas clause? Is that where we're starting? What do you think,
Well,
Lisa?
okay, my thought is, if a homeowner purchases beachfront property, they're deeded to the wet sand. If a person purchases in a private development, and I don't want to mean private, but a development community, such as Seaside, Watercolor, Rosemary Beach, that beachfront within the boundaries of those communities is considered Rosemary Beach, not a public beach. So what established that? In 1970, if they were doing, or 74, whatever it is, if they had customary use before then, why weren't these communities and all these homeowners up and down the 26 miles told, okay, now you're going to buy to the wet sand, you're going to be deeded to the wet sand, but then now all of a sudden, 30 years later, you don't have that access? That's my question.
Rob, can I?
Okay, and do you have an answer to that?
History is like when Seagrove was established. Before, there are a lot of communities that aren't beachfront. There's hundreds and thousands of that fit into that category of that are applying to the economy. But like when Seagrove, for instance, it used to be Russ Hammock. It was the Hammocks before it was Seagrove, before Cube named it that. But it had deeded public beach access. Specifically, they did. But then there wasn't Seaside until really just recently, just 35 years ago, and then
Rosemary was
so those are all
1995.
fairly new. There have been lots and lots of homes and people that have either bought to invest and rented their homes that live blocks and miles off the beach,
Right.
or Point Washington, or heck, Freeport for that matter, or Defuniak for that matter, that they invested in their homes or bought it as a place because they loved it and used the beach customarily. So it's not just the Rosemary beaches of the world or the watercolors, water sounds, Sandestin, whatever the communities have. There's also all these hundreds and thousands of upland homeowners and users that have been using it. And they part of their investment or not. So I hope that kind of is not just since these little communities came in.
Okay. Let's hear one final comment from Celeste, and then I have a quick close before we hear from the public.
About a year ago, I started reading about customary use when I found out the beach that I had customarily used all of a sudden was quiet titled. So there's a lot of good information out there. And here's the thing, and it's still owned by Rosemary Beach. The beach is still owned by whoever purchased the property or quiet titled it or whatever they did. They still own that beach. But my understanding of it, and I'm just kind of reiterating back what I've read on customary use, the customary use is a different right than ownership. And that is a right for the public, and please correct me if I'm wrong here, but my understanding is that customary use takes nothing from the beachfront property owners. It is a use. The beachfront property owners still own that property, but the public has the right to use it. Now, that's where I can see already where the customary use ordinance is sort of, we're getting into issues that are the beach activities ordinance. That's a whole different thing, and that's where what happens and what the public does on these beaches is governed by that ordinance. And I mean, that's where if you got issues with the activities, you need to get on the committee that's going to discuss the beach activity ordinance. This is the customary use, and customary use is a legal defined term. We can't make up what customary use is, my understanding, So you may own the beach, but that bundle of rights does not include the fact that you can exclude the customary use.
Okay. Thank you. Then let me ask the committee members if you'll accept some homework. Our next meeting is going to be same time, same station, same place in a week, Monday at 5. If you would go through the whereas clauses on your copy of the customary use ordinance, I think in colors sometimes, so green next to it or highlighted means I like this one, I agree with it in its entirety. Yellow means I need to make some changes to this one, and then think about what changes you would recommend, because we'll get into that. And red means this one is so badly flawed that it cannot be saved, it needs to be ejected from the ordinance. All right? So green, yellow, and red. Yeah, David?
What about the whereas clauses that aren't on the piece of paper?
Okay, perfect. Good point. Good point. If you got some new ones to add, write them down. Write them down and bring them in, and bring 12 copies or 13 copies, if you will. Okay?
Blue?
Blue's great. Blue is great. I want to finish my part of this, and then I'll turn it over to the judge for the public portion, with an excerpt from a book that I've been reading. It's called The Shack, and it's actually in movie. That's in the trailers in the movie. The movie trailers are in the theaters now. And in that book, a man suffers just a devastating loss. And most of the book is about his relationship with his God. And it's a book that has a Christian faith foundation, and so it covers conversations he ultimately ends up having with the Father, Son, and the Holy Spirit. And regardless of where you are there, I think some of the language is instructive, and I thought it might inform the flexibility that I'm asking you all to keep in mind. And there was one point where he was struggling with things that he knew to be true. And he's having this conversation with one of the members of the Trinity. And the response talked about paradigms being what you believe. And this is from the book, The Shack. Paradigms power perception, and perceptions power emotions. Most emotions are responses to perception, what you think is true about a given situation. If your perception is false, then your emotional response to it will be false too. So check your perceptions. And beyond that, check the truthfulness of your paradigms, of what you believe. Just because you believe something firmly doesn't make it true. I think that's a challenge to all of us, not only here, but in other aspects of our life, but we'll limit it for here. All right? I'll leave you with that. Judge, it's all yours.
We have one business that I don't think we covered here, and that was to decide what voting group would constitute a majority. Those present voting, those voting, or all members? Did we decide on that?
I thought we deferred to the attorneys.
We didn't make a decision on that because the original motion did not carry that it be unanimous, okay? So we need to make a decision. For a majority vote, who are we looking at? All those present, those just voting, or all members?
It
Yes.
seems like we deferred to the attorney is what we did.
What-
I make a motion that we refer to all those voting.
Okay, there's a motion that the majority be counted by all of those voting. Is there a second to that?
I'm not sure I understand.
You have three options of people: those that are voting, those that are all present, and then all members of the committee. Her motion is that only those voting constitute a majority, if there is a majority vote. So there's a motion. Is there a second to
Yeah,
this?
I still don't understand. We're talking about what makes a majority, what number, and it's only the people present, so if you were absent, the number
Who are
changes.
those eligible to constitute a majority? All those voting, all those present, or all those on the committee?
So if you're present but not voting,
If you're present and you're not voting, then the majority would be whoever's voting plus one.
okay, so you would remove me from that vote.
If you would abstain,
Okay.
that would be your option. So that is the motion. Do we have a second to that motion?
I second.
There's a second to that motion. Discussion, please.
Mr. Chairman, the number is an issue that we adopted a motion to have comment from the mediator. Is that a separable issue from this motion?
That was the number that we chose to be a quorum. Is that what you're talking about? Six?
After that, we had a motion to have a positive action of this committee, a recommendation of this committee to require a unanimous vote, and that failed.
That failed.
And then I made a motion that we solicit the input of our mediator or the county.
And that
Passed unanimously.
passed
Yes,
unanimously.
sir.
Okay.
So we never came
Okay,
back
so,
to the number.
Mr. Mediator, do you want to give us a recommendation?
On what constitutes a majority?
Yeah.
How about should we follow through with what passed unanimously? There was no opposition to
That's
that.
not what I think I made a motion.
No, and my intention of my question had to do with, we separated these two. First, we're gonna-
You're
okay.
correct. You're absolutely correct. Your motion passed, and so we will ask Mr. Neely if he wants to make a recommendation, or do you want to wait on the county attorney's recommendation?
That's what I was gonna suggest,
Yeah.
Mr. Chair, is.
What do you want to do, wait on the county?
Well, and it wasn't my intention to confuse disposing of the motion on the floor. I just wanted to make sure that,
Do you want to wait till the county's attorney's recommendation comes in?
Do you want me to act as the county attorney for
Yes,
tonight's
you
purpose?
may.
Okay.
County attorney is here,
I
ready
guess
to
just
make
to-
a recommendation.
I guess just to give you guys some guidance.
Thank God, Sydney.
To give you some guidance about how some of our other boards work, generally it depends. Some of them are specific. Some of them require 4 unanimous votes if those are the only people that are present. But generally, it's a simple majority for motions to pass.
Of
for
those
all of our-
Simple majority of who?
Of those present.
Of those present, okay.
Present and voting.
Present and
That's-
voting,
yes,
present
yes.
and
Yeah,
voting.
so
All right.
there's some exceptions to that rule, but that's generally the rule for most of the county's advisory committees and planning
Okay.
commissions and things of that nature.
Question?
So that's the county attorney's recommendation, is that those present and voting, that the majority has to be of that group of people.
Yeah, I didn't hear her that way. I heard her saying that's one of our options.
But
That's right.
She didn't recommend that we
Yeah, that's her
do it
motion.
that way.
That was
Well,
She made a motion
she
on
didn't
that?
make a motion. She's not on the committee. She came back.
But Lisa,
But this was the motion that we had on the floor.
So
Correct.
is Mr. Bailey's motion,
I-
somebody has
and
rescinded that
again,
somehow, or
Well,
what's going on here?
Mr. Bailey's, well, we got 2 motions going on. Your motion was to get a recommendation of the county attorney, which preceded your motion. I'm sorry to say that I forgot about that. Okay, we were given a recommendation now by the county attorney that majority constitute those present and voting. Okay, now, I'm open for a motion on whatever this committee wants to do. You don't have to take a recommendation.
Mr. Chairman, if I could, the intention of me requesting the input of the county attorney and the mediator, and Mr. McNeely began talking about it very early in your presentation, about how we will arrive at some useful recommendation, hopefully. And I believe from one of your earlier comments is you have a great interest in that. I think we all have a great interest in that. And so my question to Mr. McNeely is there a number, less than everyone, that will help us get there? A supermajority?
I understand, and what I will tell you, that in my world, right, when I'm facilitating discussions, ownership of the result of those discussions rests with you all, right? And so I candidly, I like doing things by consensus for the reasons that I mentioned earlier. I think since you're a body of the county commission, you do have a certain set of procedural rules that might best be followed that way, the way that Sydney said the other sub-units of the county commission do their work. It makes sense to me, so I don't really have a recommendation for how.
All right, Rob punted. Okay, now, I'm down to a situation now where if we ever get to a point of having a motion and trying to adopt one, I've got to report to the county commissioner what our findings were. I'm simply asking you to tell me what is it going to be? How are we going to vote?
So do we have the option of postponing this?
No, judgment.
No, you can't
Chairman,
sir.
We have a motion
Just
on
asking.
the floor. The
We
motion
got a
on the floor
motion and you got a
is
second.
seconded, and I would move the previous question.
You move, the previous question is moved. There's no more discussion on the previous question. All in favor of the motion on the floor? That is, the motion being that in order to have a majority, the majority must be a majority of those present and voting. Does everybody understand the motion? All in favor of the motion?
Aye.
Any nays?
Nay.
One nay. The ayes have it. We're now open for public discussion. And we will end the public discussion in another 20 minutes, okay? Thank you.
Thank you, Judge. Committee members. I think your facilitator was correct in that the issues are intertwined. And I think that was pointed out when Celeste made the comment about Rosemary Beach. When you look at the uses, as I think Lisa pointed out, what uses are you talking about? They are intertwined. You can't separate. Even the beach activities ordinance is about uses. You know, I don't think anybody would disagree that walking up and down the beach was a customary use. Sitting in the sand, customary use. Maybe little beach chairs, customary use. You start talking about tents, you start talking about coolers, you start talking about all these other activities that are going on. Those aren't customary use, A. And B, you don't have that customary use for the whole 26 miles. You have it for the 6 miles of the state parks, you have it for the 2 miles of the county parks, but you don't have it, as Celeste pointed out, in Rosemary Beach, because the public does not have the code. Now, the public can go down to the public beach access point and walk down the beach, but in the 10 years I was there, I never saw anybody go down that public access beach and drag stuff to the western green, or even the eastern green, which is about 500 feet away from that beach, that public beach access point. So it has one of the, I would urge you to go back and look at the 4 concepts that the expert told you, or told the Board of County Commissioners, had to be present for customary use, because I believe one of those was not just ancient, but uninterrupted. So when Rosemary put the gates up 10 years ago, it interrupted the public using that beach. We have chased people from Seacrest, no offense if you were one of those when you owned in Seacrest or whatever, but from Seacrest Beach, from Inlet Beach, off because they were crowding the people who owned that section of the beach. But there are parts of the beach that probably have had customary use uninterrupted. But that wouldn't be in Sandestin, although there is public beach seaward of the erosion control line, all the way from 4 Mile Village to the Okaloosa County line. Now, the question is, you know, how you get access to that section of public beach, but once you're on that public beach, it's public beach just like the public beach at the county parks, just like the public beach at the state parks. So if you go back and you look at the 4 requirements that were set up, and you look how that's been applied, I think you're going to see that one of your recommendations is, let's all get along together. Let's limit even further than the Board of County Commissioners limited the customary uses. Walking, you know, I have an issue with fishing, but some people would say that. My time's up, and I know a lot of people want to speak.
Thank you, Jim.
One of the things I'd like to suggest to the...
Would you say your name? What's your name?
Yes, Gary Drake, D-R-A-K-E. One of the things I'd like, we talked about the purpose, Mr. McNeely, and what it said, what he quoted was the report recommendations, ideas, alternatives, or amendments to the ordinance that would best serve the residents and visitors. And I'd like to suggest that you add to that a third, and just as important, member, and that's the littoral and beachfront property owners, that they also be considered when these ideas and recommendations and alternatives, in addition to residents and visitors. The other question I'd like for you to think about and consider is how, or can the public who can't attend submit questions and or statements for future meetings, and how would they do that? So if you that's, appreciate the consideration for that. Thank you.
Thank you, sir.
Jackie Markell. One of the things that Walton County has suffered from over the years is lack of vision and lack of long-term planning. I think the issue of customary use is enormous for the whole breadth of our community. I'm thrilled that the commissioners did this. I really applaud every one of you for sitting here and taking on a challenge like this. But I also want to caution that the establishment of customary use, any recommendations that you make that would remove or compromise customary use, the customary use by the public of the beaches, we can't go back from. If a right is given away where customary use has been established, we can't go back in 5 years and say, oh no, we want that back again. So I would just caution to consider very carefully the recommendations that you make for the good of the whole county, people north of the bay, people that aren't beachfront, people that own property, have invested property, that rent their property based on the fact that their visitors can get to the beach. And also a question was raised, is there really a problem? Well, there really is a problem. There is a problem, and it's getting worse. And as our tourist numbers increase and as development increases, the issue gets worse. The issue of quiet titles has muddied the water here. So I'm just saying, please carefully consider that any compromise that you make to the customary use by the public of the beaches is something that we can't go back from in 5 years. But thank you for all serving.
Thank you.
My name's Bob Brook. I still, despite what Celeste said, have a very vague notion of what customary use actually allows and does not allow. I spend a lot of time walking on the beach, sometimes as much as 7 miles a day, and I very rarely have any issues with anybody telling me I can't walk on the beach. In fact, I've never had anybody in the almost 10 years I've lived here, actually 11 years now this month, 11 years in a couple of days, that I've ever had anybody stop me from walking on the beach. I guess my biggest concern, and again, I've heard people say you used to be able to walk on the beach and you wouldn't run into anybody in 1970. Well, I can tell you in 2006 I could walk on the beach in March and I might run into one person in 3 or 4 miles of beach. Now, I have a real question because I'd like to know, under customary use, as this group defines it, or as the county defines it, or as the law defines it, what does that permit? What does customary use allow? You used to see one person on the beach in 3 miles. On private property, which the county says they're not going to take our private property rights away for beachfront owners, but they tell you that customary use allows anybody in the public to use that beach. Now, is that one person per, say, 100 square yards? Is that 50 people per 100 square yards? Is it 1,000 people per 100 square yards? What is customary use? And I think you could do a great service to the county in terms of giving them a recommendation as to what is customary use and what does it mean to the people in this county, especially the people who live on the beach and will have to put up with the 1,000 people that camp in front of their house. A second issue that came up during some of the discussions with the county was who's liable for harm that comes to somebody who's using your beach, so a non-owner who's using the beach that's private property. The county kind of waved their hands and said, we're not responsible for it. I guess that means get insurance, but those are the kinds of issues that property owners, I mean, people who come to the beach for a day and walk away afterwards after they've trashed it, dug holes, and all the other kinds of things that they do, don't have to worry about what happens when somebody falls in that hole and breaks a leg and wants to sue the person who owns the property. So those are the kind of things that concern me as a beachfront property owner and the things I wish you would consider. Thank you.
Thank you, Bob. Yes.
My name's Will Dunaway. One of the most insightful exchanges from my part that occurred when Mike Huckabee and Mike Sturdivant were talking, and the question that Mike Huckabee asked was, is this an access problem or a behavior problem? And Mike Sturdivant immediately said it's a behavior problem. And one of those things, and I think Ms. Bauschy then picked up on that and said, wouldn't we do a good service if we, this group and the county, had some education on what it is that we need to do to get along on the beach? I think you just talked about it here, and it came up on the issue of access. Access is different than customary use. That's a very important issue. Customary use, because the legal expert told you, because that's what the law is, that to establish a custom, it must be ancient, reasonable, without interruption, and free from dispute. So the 26 miles of the beach are different because different areas of the beach don't meet all of those criteria. Mr. Bagby gave examples of those areas that probably do. The public beaches, certainly the public beaches that the county and the state own, they certainly are. But Rosemary Beach, as we're talking about, that's different. Seaside is different. Private property owners have differing, their areas are different. Different private property owners have different deeds. Some, as Lisa indicated, own to the mean high water line. Some don't. Some have there are deeded accesses that come from the public roads down to the water's edge. There's no denying that the state owns all of the beach seaward of the mean high water line, without question. No doubt. The public can be there all the time. That's often referred to as the wet sand. But nevertheless, that's what the beaches of Walton County are available for the public. All that area seaward of the mean high water line. Then I just want to briefly state that what Dave said, David mentioned, and he made a comment, he goes, you can't put a price on the beach. I think I understood what you mean, meaning that it's precious, it's valuable, it's very important. But I say that you can put a price on the beach. There's beachfront property today that's for sale. You can go buy it. The county has been buying it with some vigor, and they have purchased and they put prices on the beach, and that would make for a valid ordinance, which had just compensation for the public taking.
Thank you. Other comment?
Sorry.
No.
Okay, other comment?
Hi, my name is Julie Hilton, and I just want to thank all of you for your taking the time and having the patience to participate in this committee. And I think it's a real challenge to, and the mediator as well, I appreciate his involvement. I'd like to, there's been a lot of discussion about customary use, needless to say, and our families purchased some lots in Walton County on the beach in the 90s, and my parents live here. My brother built a home and is deceased, but I think the statement that Mr. Dunaway just mentioned is what I understood to be what people historically had done on the beach. Used to be, I lived in Bay County, and it used to be, I mean, there was no one in Walton County when I was growing up. No one. Hardly anyone ever, showed up on the beach. You could walk for miles and not see someone on the beach. But no one, I think, would dispute the fact that all of us as citizens or residents or just people are allowed to walk on the beach, to swim on the beach, to surf on the beach, to put their towel on, an area near the water, and no one is disputing those things. And I saw in the arguments over and over in the county hearings, people say, well, in fact, one of the commissioners who voted for this customary use said, well, I love to walk on the beach. I agree with her. I love to walk on the beach too, but no one's stopping anyone from walking on the beach or swimming on the beach or surfing on the beach that I know of. And if they do, perhaps this committee needs to point those out. I think Governor Huckabee's comment is very important, because I'm not really sure what people are kept from doing that they want to do that you genuinely think should property owners should give people the right to do. I mean, should they be allowed to do just whatever in the heck they want to, drink and carry on, and have their parties on your doorstep? Is that what you're asking for? I don't know, and I would really appreciate perhaps some discussion about this. And I end by saying that I think that there are 900 property owners in Walton County, and as several people have alluded to, lots of variation on the history of those properties, the use of those properties. Maybe those properties have been used a long time, but perhaps have been used with the owner's permission. Anyway, there may be a variety of solutions on different pieces of property that might satisfy everyone. Thank you.
Other comment?
Hi, my name is Kelly Anderson. I just wanted to thank all of you for being on this committee. I can tell that you do not have an easy job in front of you. One proposal that I would like to make for a topic of conversation in your next meeting is the fact that whatever happens with the ordinance, we all know it's going to the Supreme Court. I would encourage you to talk about the things that you want in perpetuity, probably belong in that ordinance, the things you may want to revisit from time to time, like the size of the tent, the width of the towel, the height of the chair, are going to be better off in the beach ordinance, which you can change and modify as often as you please. Thank you.
Other comment? We have about 5 more minutes for comments.
My name is Tiffany Hughes. I'm a beachfront property owner. I just moved here, we purchased the property in May this year. So this whole customary use issue is a very big surprise for us, where we purchased, a nice property and boom, surprise, we don't have control over how we use our own property anymore. I will just say, recently I videotaped some people just letting their dog come up and run onto my neighbor's dunes and do its business and walk away, not pick it up. No big deal. They don't care. Happens all day long. There was about a month ago, some people playing Frisbee, and they started to hang their shoes and hats on our dune fencing and our neighbor's dune fencing and aiming at them. And so I went out there and, asked them to please stay off the dunes, and that was actually a law and not, just us making it up, and it's to protect the beach. And they didn't care, and we went out of town for the evening, and we came back, and my driveway was full of glass. They came and smashed glass all over, so I spent hours cleaning up my driveway. So it's very maddening when I see people say, oh, well, we've always used this. Well, use my property with respect, and maybe I'd like you there. And if you don't, you better stay off, because you will see me in court. I just can't speak anymore. So, thank you.
Thank you.
But thank you for all you're doing and actually attempting, because I don't see how this is ever going to be resolved.
Other comment? We'll have time for one more comment. Seems to have worked out pretty well. Okay. I'll entertain a motion to adjourn.
So moved.
So moved. Second. Don't need a second.
Okay, we worked hard.
Good to see you.
You too. You too.